Welcome to The Explainer. Today we're looking at the $1.776 billion settlement and the Constitution. We're going to unpack the mechanics of a massive, completely unprecedented legal roadblock that has frankly stunned the American legal system. We are sticking strictly to the facts here, looking at the timelines and the really fascinating constitutional mechanics at play, without taking any political sides. If you want to understand how the branches of our government interact when they're pushed to their absolute limits, well, you are in exactly the right place.
$1.776 billion. Let that sink in for a second. That is the staggering size of a settlement fund that was just abruptly frozen by a federal judge. To put that into perspective, this isn't just a rounding error. This is a massive multi-billion-dollar payout involving the public fisc, which literally means taxpayer dollars. And it was negotiated entirely out of court before being brought to a screeching halt.
So how does something like that even happen? Well, it all comes down to a question that honestly sounds like a brain teaser. Can a sitting U.S. president actually sue his own administration, negotiate a multi-billion-dollar settlement with himself, and then distribute those funds? It's a scenario that has tested the very boundaries of the American judicial system, and the answer lies right in the intricate details of a highly unusual lawsuit.
Section 1, the $10 billion lawsuit. Because to understand the settlement, we really have to look at how the lawsuit itself began. To truly grasp the sheer magnitude of this thing, let's walk through this chronological whiplash, okay? The roots of this billion-dollar dispute actually start with a single individual and a massive breach of privacy. It all started back in 2023 when an IRS contractor illegally leaked the tax returns of Donald Trump to the press. Fast forward to January 2026, and President Trump, acting completely in his personal capacity, files a massive $10 billion lawsuit against the IRS and the Treasury Department for the leak. By May 2026, the Department of Justice announces they've settled the case out of court, but then, almost immediately, a federal judge steps in and slams the brakes on the entire agreement. Section 2, a historic settlement reached.
Okay, let's dive into this, because the details of this sudden, out-of-court deal, brokered by Acting Attorney General Todd Blanche at the Department of Justice, are just astonishing. It wasn't your standard financial payout. The settlement had three main components. First, the creation of a $1.776 billion anti-weaponization fund financed by the Treasury Department. Beneficiaries of this fund were purportedly expected to include individuals who claimed they were unfairly targeted by the government, which actually included convicted January 6th rioters. Second, it required a formal apology from the United States government to the plaintiffs. And third, it granted the president and his affiliates absolute immunity from future IRS audits and investigations. It was, without a doubt, a historic agreement. Section 3, the judicial intervention. This is where the narrative shifts to the abrupt judicial roadblock that halted that multi-billion-dollar agreement. Just as the DOJ announced this massive agreement, the federal court intervened in a way that totally shocked legal observers everywhere. And what's wild is that it wasn't just the presiding judge raising alarms. A highly unusual intervention took place when 35 bipartisan former federal judges stepped forward. They penned a letter warning the court that something far greater was at stake from just a simple case dismissal. They argued that the integrity of the entire judicial system was basically being bypassed. This whole intervention culminated in a searing 56-page written rebuke by U.S. District Judge Kathleen Williams, an Obama appointee. She firmly blocked the settlement, and she did not mince words. She wrote, "Certainly, a court should not be a forum for a party that cynically views a lawsuit as a vehicle to achieve a predetermined outcome. I'm suing myself." That exact phrase, "I'm suing myself," is the absolute crux of why this settlement was voided. Former U.S. District Judge Shira Scheindlin, who was one of those 35 intervening judges we just talked about, explained this dynamic perfectly. She pointed out that because the president was effectively on both sides of the litigation, standard legal procedure was entirely bypassed. As she put it, there really was never a case. A judge just never got the chance to fully investigate, accept briefs, or make an actual ruling before this massive settlement was suddenly announced. Section 4, the constitutional question. Let's look purely at the objective constitutional law here, completely avoiding any partisan noise to focus purely on the legal mechanics. And this brilliantly illustrates the core problem. Imagine playing a game of chess against yourself. Think about it. On one side, the plaintiff is Donald J. Trump in his personal capacity, seeking $10 billion. On the other side, the defendants are the IRS and the Treasury Department. But the Treasury and the IRS are executive agencies overseen by officials appointed by and reporting directly to the President of the United States. You have the exact same entity moving the pieces on both sides of the board. This actually brings us to a fundamental pillar of American law found right in Article 3 of the Constitution, the case or controversy requirement. The American judicial system strictly requires that federal courts only decide actual, legitimate disputes. For a court to have jurisdiction, there must be two opposing sides with genuinely adverse legal interests. Simply put, you cannot have a trial where both sides secretly want the exact same outcome. And that leads directly into our next critical legal concept, collusion. When that required constitutional adverseness is missing, courts step in. Judge Williams applied this exact definition to the settlement negotiated by Acting Attorney General Todd Blanche. Because the executive branch was negotiating with the president's own personal legal team, the judge noted it was risible to suggest that there was ever adverseness between the parties. Now, what's really interesting about this slide is the concept of dominus litis, which translates to the master of the suit. In her 56-page order, the judge highlighted the observation that the president exercises actual, comprehensive control over both the executive branch defendants and his personal legal team. Because he's the chief executive, he has the power to appoint and remove the heads of the Treasury and the IRS. Therefore, he acts as the master of the suit on both sides, which just completely breaks the constitutional requirement for an adversarial legal system.
Section 5. What happens next? Let's talk about the fallout and why this constitutional breakdown actually matters to you.
So, the crucial point is, with the $1.776 billion settlement voided and the Constitution invoked, what happens now? Well, the judge didn't just stop the payout. She reinstated the lawsuit to actively investigate whether this entire case was a fraud perpetrated on the court. She's looking into Rule 11 sanctions, which are severe penalties designed to punish lawyers for frivolous filings and deceiving the judicial system. And we are already seeing immediate, real-world fallout for the personal attorneys involved in the case, which really shows the severity of this ruling. Attorney Alejandro Brito was officially referred to the Florida bar for disciplinary review. Another attorney, Daniel Epstein, was completely banned from seeking admission to practice law in the Southern District of Florida for 1 entire year. The judicial system is fiercely protecting its integrity here. Which leaves us with a profound, really provocative final question about the integrity of our government. If the executive branch can legally negotiate a multi-billion-dollar settlement with itself, using taxpayer funds to bypass the courts and Congress, where does the separation of powers actually end? This case is far from over, and its outcome will likely define the boundaries of executive power and judicial independence for generations to come. Thank you so much for joining me for this explainer, and I really hope this leaves you wanting to dig even deeper into how our Constitution works.